Good afternoon. Welcome to the Analyst. Today we'll be taking up 7 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll take up is related to ports and shipping sector, as the Ministry of Shipping has launched the One Nation, One Port process and the Sagar Aankalan, the Logistics Port Performance Index. The second article is related to India-Bangladesh relations, as the history textbooks in Bangladesh are being rewritten, underplaying the role of India in its liberation war. Additionally, we'll take up 5 articles in the simplified which will be helpful in your prelims and mains preparation. Now, the first article is related to the ports and shipping sector. The government wants to standardize and streamline the port operations across the country. It wants to improve the port efficiency, so it has unveiled the One Nation, One Port process and the Sagar Aankalan, that is the Logistics Port Performance Index. So we will discuss the government initiatives regarding the ports and shipping sector and the significance of this sector. This is important in GS3 under the topic Infrastructure Ports. Now first let's have a look at the basics regarding this sector. India has a long coastline of about 7,500 kilometers. So it has the opportunity to utilize the same to promote shipping as the chief trade route with the other countries. But when we look at the logistics sector as a whole, ports contribute to about 5% of the logistics in India, whereas the roads contribute to 57% of the logistics sector. When we look at the logistics cost as a percentage of GDP, again we are spending too much on the logistics. Logistics cost as a percentage of GDP in India is about 14%, whereas in the BRICS countries it is just about 10%. In USA it is even lower at about 8% of their GDP. India's external trade is handled by the ports, the significant chunk of it. 90% of India's external trade by volume is handled by the ports. 70% of the trade by value is handled by the ports. Likewise, the Indian Ocean, which accounts for 1/5 of the world's sea area, accounts for a significant chunk of the global maritime oil trade. 80% of it passes through the Indian Ocean. It shows the significance of the maritime sector for India as well. In India, there are 13 major ports and 212 non-major ports. The major ports, they are governed by the central government through the major ports trusts, and the non-major ports are governed by the state governments. The governance models are chiefly of two kinds, the service port model and the landlord port model. In the service port model, the port authorities perform both the functions, the regulatory functions as well as providing the services. They employ labor, for example, for cargo handling. They are providing services also, the port services, to the people who need transport, who need logistics services. Whereas in the landlord port model, the port trust, they are only acting as the landlord. They own the port, but the operations are handled by the private players through a PPP model, the public-private partnership. The port services are performed by the private players. But when we look at the capacity utilization of the ports in India, it is just about 55%, which needs to be improved. Let's also have a look at the World Bank's Logistics Performance Index. As per the 2023 report of the World Bank's Logistics Performance Index, India is ranked at the 22nd place on the international shipments category. This is a significant improvement from the 44th place in 2014. Why it has improved? Because of a few indicators. For example, the dwell time is the time that the vessel spends at the cargo terminal, usually for the loading and unloading operations. In India, the dwell time is just about 3 days, whereas in the case of USA, it is 7 days. In the case of Germany, it is 10 days. Likewise, the port operational efficiency has improved. It can be judged through the average turnaround time. That is, in India, the average turnaround time for the cargo vessels is just about 0.9 days, that is less than 1 day, whereas in USA and Germany, the average turnaround time for the vessels is 1.5 days. Likewise, the connectivity to the hinterland has improved. because of the Prime Minister Gati Shakti National Master Plan, which improves the connectivity from the ports to the industrial hubs in the hinterland. Likewise, the investments in infrastructure have also improved, which has improved the port efficiency. Now, let's have a look at the recent initiatives taken by the government for this sector. The budget 2025-26 strives for the development of the clusters for the shipbuilders. The setting up of the clusters in the shipbuilding will ensure that there is economy of scale in the sector, bringing down the cost in the shipbuilding, and therefore the shipbuilders like the Majgaon Dock shipbuilders, Cochin shipyard, Garden Reach shipbuilders, they will benefit from this. The budget also revamps the shipbuilding financial assistance policy. The shipbuilders require financial assistance because the ships cannot be mortgaged under the SURFACE Act also, and the ships are not treated as infrastructure, therefore they are not able to get the infrastructure loans as well. Although the budget now includes the large ships as infrastructure in the infrastructure harmonized master list. There is also the introduction of the credit notes for the ship breaking in the Indian yards. The budget sets up a maritime development fund. This fund will have a corpus of 25,000 crore rupees and it will be providing long-term financing for the maritime industry. Out of this 25,000 crores, government will be contributing 49% and 59% of this fund will be coming from private investments and the ports. What are the objectives of this fund? It will be helping in the development of new ports and the modernization of the existing ports. It will be giving financial aid for the green shipping initiatives. It will help in promoting investments in the ship repair facilities because we want to ensure that India becomes a global shipping hub. It will encourage the technological innovations in the maritime logistics as well as the improvement of the fleet efficiency. The budget promotes the expansion of the Prime Minister's Gati Shakti portal and it encourages the port-led PPP projects. The proposals for these port-led PPP projects will be given by the states and this will enable the support from the India Infrastructure Project Development Fund. Therefore, it will promote the emphasis upon the modernization of cargo handling infrastructure, the development of multimodal logistics parks which are there near the ports and the connectivity enhancement between the ports and the hinterland via road and rail networks, ultimately promoting the efficiency in the logistics sector. The budget also extends the tonnage tax scheme to the inland vessels as well. The tonnage tax scheme promotes the levying of the corporate tax depending upon the total tonnage that is carried by that cargo player, and now it will be extended to the inland vessels as well. Earlier it was only for the sea-going vessels. The government also came up with the Maritime India Vision 2030. This is a 10-year blueprint and this is the latest venture of the Sagarmala program itself. It is to promote investments in the maritime sector, investment of more than 3 lakh crores, and to increase the cargo volumes to ensure that more cargo is transported through the shipping route. This will lead to the creation of more jobs. Already, India is contributing more than 10% to the global maritime workforce, and it will also be a source of revenue for the state-owned major ports. Now the government has also unveiled the One Nation, One Port process which will streamline the port operations, and the Sagar Ankalan, which is the Logistics Port Performance Index. Through the Bharat Global Consortium, key memorandum of understandings have been signed with various countries for ensuring global collaboration in the maritime sector. There is also a National Center of Excellence for Green Ports and Shipping. This will be strengthening the governance architecture for the ports. Through the Maitri initiative, India will be able to connect with the countries through a virtual trade corridor. Now let's also have a look at the institutional framework which governs the ports in India. The major ports in India are governed by the central government through the Ministry of Shipping. Earlier there was the tariff authority for major ports as well, which used to determine the tariff rates for the services provided by the ports, but now it has been replaced by the adjudicatory board under the Major Port Authorities Act of 2021. Therefore, the major port trusts are set up and they are governing the major ports, both public as well as private terminals. And the Ministry of Environment and Forest gives the guidelines related to the sustainability and environmental conservation to the major ports. Whereas the non-major ports are governed by the state governments, the state maritime boards or the state government departments are set up which govern the non-major ports, and the environmental guidelines are given by the Ministry of Environment and Forest only for the non-major ports also. Now let's also have a look at some of the earlier policies and legislative reforms to have a comprehensive overview of this sector. In 2021, the Major Port Authorities Act was enacted. This act provided for the constitution of Major Port Authorities Boards. These boards determine the tariffs which are to be imposed by the port authorities while providing various services related to the ports, for example, cargo handling. It also provided for the constitution of Adjudicatory Board. This Adjudicatory Board will replace the Tariff Authority for major ports. The tariffs which were decided by the tariff authorities, they are now decided by the authorities boards, and the disputes are resolved by the Adjudicatory Board. The Marine Aids to Navigation Act was also enacted. It is to ensure the safety and efficiency in the vessel traffic services through uniformity in regulation, and it provides for the training and certification as well to ensure that the standards are the same as the international standards. In 2021, the Indian Vessels Act was also enacted. Through the Indian Vessels Act, the uniformity in registration of Indian vessels, the regulation of Indian vessels is ensured. The draft Indian Ports Bill was also proposed in 2022. The FDI has been extended to 100% in the port building, harbor building, and the maintenance of ports. To ensure that there is decarbonization in the maritime sector, the government also came up with the Panchamrit commitments. To promote decarbonization, there is an increasing use of renewable energy in the port sector. For example, floating solar power plants. There is the Harit Sagar Green Port Guidelines issued by the government, and the discharges and effluents in the harbor water are regulated strictly. The construction of multimodal terminal has been taken up in Jogigopa in Assam. Through the draft Indian Ports Bill 2022, the government wanted to ensure environmental compliance. The environmental compliance is needed because we are also a signatory to the International Convention to Control Marine Pollution, the MARPOL Convention as it is popularly known. We also wanted to ensure the institutional reforms, for example, the setting up of state maritime boards, to ensure a streamlining of dispute resolution, to establish a national council for the maritime sector, to set up a maritime state development fund. This has already been set up by the budget 2025-26. The significance of this bill was to ensure the optimum utilization of the coastline, essentially to promote the port regulation and efficiency, to address the logistics bottlenecks, to promote connectivity with the hinterland, and to ensure that India becomes a major trading hub as well as a global shipping hub. But there are a few concerns as well which need to be addressed. For example, the Maritime State Development Council, it was set up through an executive order. It is an executive body, but it is vested with wide powers, unbridled powers. Therefore, there is an element of centralization which is often seen in the initiatives taken by the government. But it is often said that the non-major ports which are governed by the states, they have performed better. As per a World Bank report of 2011 also, the non-major ports, they have a business-oriented program and they have performed better. The share of the total cargo which is handled by the non-major ports, it has gone up from 8% 3 decades back to about 45% in 2021. Now, why do we want to invest in the maritime infrastructure? Why is the government promoting this sector? Because it is crucial for our economic security. For example, we can observe there are disruptions across the globe. Like in the Red Sea, there are attacks by the Houthis which disrupt the shipping, which increase the freight cost and also cause delays in the shipping. And we are also dependent upon the foreign vessels. 95% of India's international cargo is transported through vessels which we have imported. which were built abroad. Therefore, we need to promote our domestic shipbuilding industry so that we do not become victims of supply chain disruptions, because in the scenario of a geopolitical turmoil, the other countries may refuse from exporting the foreign vessels to India. It will also lead to a saving in the foreign exchange reserves. Geostrategically looking as well, it is quite important because we are located in the Indo-Pacific and we want to promote security and growth for all in the region. We want to promote the India, Middle East, Europe economic corridor. For that, we need to invest more in shipping and ports. We want to achieve our environmental goals also, and to ensure that we fulfill our commitments as per the Conference of Parties 28 and the International Maritime Organization's net zero targets, we need to invest more in shipping. It will promote economic growth as well as it will lead to the employment generation as well. Therefore, the Prime Minister has come up with the vision, the Maritime Amrit Kal Vision 2047. And it is projecting this as an opportunity as well, as an investment opportunity to invest 80 lakh crore over the next 23 years. It aims to create port clusters, 4 port clusters. It aims to set up transshipment hubs at Vizhinjam and Galathia Bay. And the target is that of increasing India's share of transshipment cargo to 95% by 2047 from currently 32%. And it also aims to enhance the modal share of coastal shipping and inland waterway transport in general. Now, what are the suggestions that you can give for the ports and shipping industry? For the domestic shipbuilding, we can say that the government can set up a national shipbuilding mission. The government can also come up with a production-linked incentive scheme so that the shipbuilders, they invest more and increase their production capacity. We can encourage long-term financing as is done through the Maritime Development Fund as well. The government can give tax incentives to the shipbuilders to encourage them to increase their fleet size. We can also explore the public-private partnership models also for the shipbuilding industry in India. To promote coastal shipping and inland waterways, the government can set up multimodal logistics hub as well. Under the Prime Minister Gati Shakti National Master Plan, we can ensure last mile connectivity to the industrial hubs, from the ports to the industrial hubs. To encourage green shipping, we can set up solar powered ports. The hydrogen powered ships can be built. We can build an electric ferry fleet as well, as is done by Norway. For the promotion of port efficiency, we can adopt automation, artificial intelligence and the Internet of Things as well. Now, there is a mains practice question as well. Examine the significance of the ports and shipping sector in India's economic growth. Analyze the key government initiatives undertaken to bolster the sector and suggest measures to enhance its efficiency, sustainability and global competitiveness. Please try to write it. Now, the next article is related to India-Bangladesh relations. The context behind it is that history textbooks are being rewritten in Bangladesh by the present regime, and it underplays the role that India played in the liberation war of Bangladesh in 1971. So, we will discuss the significance of India-Bangladesh relations, the challenges that it faces, and a few suggestions in this regard. This is important in GS2 under the topic India and its neighborhood relations. First, let's have a look at the significance of India-Bangladesh relations. Why does India need Bangladesh? Geostrategically looking, Bangladesh is the eastern neighbor of India. It acts like a bridge to Southeast Asia. And we need peace and stability in Bangladesh, because if there is turmoil in Bangladesh, it will outpour into India as well, because we share a long land boundary with Bangladesh. A large part of that is riverine in nature. Therefore, we need cooperation from Bangladesh for ensuring regional security and peace. Economically as well, Bangladesh is important because it is the 5th largest export destination from India. We export pharma products to Bangladesh. We import textile products from there. We have energy cooperation with them because India is setting up Maitri power plant there. We have built the India-Bangladesh friendship pipeline through which we give them high-speed diesel. Likewise, there is the setting up of the LNG terminal as well by India. When we look at it from a security aspect, there are hostilities in Bangladesh. For example, the Bangladesh Nationalist Party, it is alleged to have links to the ISI in Pakistan. Likewise, the Jamaat-e-Islami in Bangladesh, a political party there, is hostile to India. It is viewed as an Islamist party. But the Sheikh Hasina-led Awami League was seen to be pro-India. Simultaneously, there is a deteriorating situation in Myanmar as well. Therefore, we need cooperation from Bangladesh in the security aspect. Hence, we used to conduct the joint exercises with Bangladesh, the joint army exercise Sampriti, the joint naval exercise Bongo Sagar. Geopolitically as well, Bangladesh is important for us because it acts as a natural pillar to India's Act East policy. We get cooperation from Bangladesh across various regional forums. For example, the BIMSTEC, Bangladesh, India, Myanmar, Sri Lanka, Thailand Economic Cooperation, the SAARC, BBIN, as well as the Indian Ocean Rim Association. And we can get cooperation from them if India is seeking the permanent membership of United Nations Security Council. Looking at it from a connectivity point of view, India needs Bangladesh to have better access to its northeast region. We can have access through the land route and inland waterways to the northeast to reduce dependency upon India's chicken's neck. Likewise, the IBP route was explored. The India-Bangladesh protocol route was explored by India, and it was explored from Maya port to the Sultanganj port recently. India has also built rail links, for example, the Agartala-Akhora rail link between India and Bangladesh. Likewise, the cooperation in the form of Chittagong and the usage of Mongla ports has been explored. There is the ties between people to people as well between India and Bangladesh. We have a shared history, a shared culture as well, and there is tourism as well which comes from Bangladesh. In 1 year, the tourists from Bangladesh exceeded that of the Western European tourists in India. The medical tourism likewise from India is contributing to almost half the revenue of the total medical tourism into India. Now, what are the challenges that India-Bangladesh relations face? Some of the challenges have arisen due to the exit of Sheikh Hasina. Ever since the Sheikh Hasina-led Awami League went out of power in Bangladesh, the attacks on minorities have increased. The Bangla-speaking Hindus in Bangladesh are being targeted specifically by radical groups. The anti-India groups in Bangladesh, they have more voice now under both the Bangladesh Nationalist Party or the Jamaat-e-Islami. And India and Bangladesh could have signed a free trade agreement. It was potential, but now the talks will be stagnated. Plus, India's dependency upon the chicken's neck will be more now because India's access to its northeast region through the land route in Bangladesh will be lesser now, and it increases the vulnerability of chicken's neck of India. The other challenges include the geopolitical challenges. For example, the anti-India militant groups in Bangladesh may find a refuge there. They will seek to take advantage of the unrest and violence in Bangladesh. Likewise, the Rohingyas, they might seek to enter into India, fleeing from there. Geoeconomically as well, the Indian lines of credit that India gives to Bangladesh, they might be threatened because of the unrest and violence in Bangladesh. India has given $8 billion lines of credit to Bangladesh. There are textile manufacturing units also in Bangladesh that are owned by the Indian entities. They might start shifting their business out of Bangladesh now. Geostrategically looking, again there are challenges because of the growing Chinese influence in Bangladesh ever since the ouster of Sheikh Hasina-led Awami League. There is the pending border dispute as well, particularly with the Indian states of Assam and Tripura, which have not been settled yet. From a security aspect, there is the challenge of armed dacoity and drug smuggling which happens across the border. The cattle smuggling happens, which has been acknowledged by the BSF also. There is the trafficking and prostitution rackets running near the India-Bangladesh border. Likewise, the trans-boundary river water disputes are still pending. They have not been settled. For example, when we look at the Teesta river water dispute, Bangladesh asks for 50% of the water from December to May. India says you will get 45% only. So the river water disputes are also pending still. Now, what are the suggestions to improve the India-Bangladesh ties? India can explore new alliances with the players who are going to come in power now, but we need to adopt a wait and watch policy for the time being, and we need to engage with the entire political spectrum. We can't be dependent upon only one political party coming into power. We need to engage with all of them, and we need to ensure that the narrative around India in Bangladesh moves beyond the 1971 only. We have helped Bangladesh even after 1971 in terms of the security, in terms of the economic development, by giving financial assistance, lines of credit, by ensuring energy security in Bangladesh, etc. We need to ensure border security by setting up a joint task force between India and Bangladesh. To promote trade and connectivity between India and Bangladesh, we can explore the signing of a potential free trade agreement. There we can focus more on energy, infrastructure and the special economic zones, setting up of SAGEs in Bangladesh as well. We can ensure the investor protection frameworks. If we are signing a free trade agreement, then the investors have to be protected to encourage investments, and we can set up a digital connectivity corridor as well to promote trade and e-commerce with Bangladesh. To ensure that we are safe geopolitically, we need to maneuver cautiously. For example, we can collaborate with the West, the USA and the European Union to counter China. We can work with the Gulf allies, for example, United Arab Emirates, to ensure that we are able to counter the extremist influence in Bangladesh. We can utilize the United Nations platform to highlight the plight of the minorities, to highlight the attacks on the minorities happening in Bangladesh. Also, India can take a principled stand when it comes to the issues like democracy and Rohingyas. We can say that democracy should be restored in Bangladesh, but at the same time, we should not interfere directly. We should not interfere in the political matters of Bangladesh. Likewise, for the deportation of the Rohingyas, India should take a principled stand again. Now, there is a mains practice question as well. Evaluate the significance of India-Bangladesh relations in the context of regional stability and economic cooperation. Identify the key challenges facing the bilateral ties and suggest measures to strengthen this partnership in the future. Please try to write it. Now, the next article is related to the GST and Customs Act and the arrests under these acts and the safeguards provided for by the Supreme Court. This is important under GS2 in the topic governance. Now, before coming to the article, let's discuss a couple of provisions from the Customs Act and the Prevention of Money Laundering Act. As per Section 104 in the Customs Act, if a customs officer has the reason to believe that a person has committed an offense under the Customs Act, then that person can be arrested by the customs officer and he should be informed of the grounds for such arrest. There is a similar provision in the Prevention of Money Laundering Act under Section 19 of the Act. Under this Act, any officer authorized by the central government in this regard or the director, deputy director, etc. can also arrest a person who he has reason to believe that the person has committed an offense punishable under the Prevention of Money Laundering Act, and he should be informed of the grounds for such arrest. These are similar provisions under which a person can be arrested. The plea in this case was that the arrest provisions under the Customs Act, they are against the arrest safeguards which are provided under the Criminal Procedure Code. The safeguards are not provided in the Customs Act. The Supreme Court in this case held that the arrest safeguards which are provided under the Criminal Procedure Code, for example Section 41B, etc., they are applicable even for the arrests which are made under the Customs Act. Earlier, it was interpreted in the case of Arvind Kejriwal. In the case of Arvind Kejriwal versus Enforcement Directorate, the court provided that the arrest safeguards, even if the person is arrested under the Section 19 of Prevention of Money Laundering Act, shall be available. One of the safeguards is the provision of anticipatory bail, that the person, even if arrested under the Customs Act, that person should also be able to apply for and get anticipatory bail. Now, what is anticipatory bail? This is provided for under Section 438 of the Criminal Procedure Code. If any person has reason to believe that he may be arrested, he has not yet been arrested, but he has the reason that he may be arrested on the accusation of having committed a non-bailable offense, then that person can approach the High Court or a court of session to seek that protection from such arrest, that he should be released on bail, and the court can provide for anticipatory bail even before the arrest. The court will consider a few things, for example, the nature and gravity of the accusation, the antecedents of the applicant, whether he has previously undergone imprisonment, or the possibility of the applicant to flee from justice, etc. Now, regarding the anticipatory bail in particular, there have been some judicial observations earlier also. For example, in Gurbakh Singh Sibia versus the State of Punjab case, the court held that there must be a reason to believe for that person who is seeking anticipatory bail that he may be arrested. It should not be based upon mere fear that he may be arrested. There must be a reason to believe that he will be arrested. And it does not require the filing of an FIR. The filing of an FIR is not a condition precedent for granting of anticipatory bail. It can be granted even before the filing of FIR. But the anticipatory bail cannot be given like a blanket bail, because it will lead to a blanket protection from arrest for any offense whatsoever. And the conditions can be imposed by the courts as per the situation and the seriousness of the region. In the state of Madhya Pradesh versus Ramakrishna Balotia, the court held that anticipatory bail is not a fundamental right. It is rather a special privilege which is granted on a case-to-case basis. In Sushila Agarwal versus State in 2020, the court observed that the anticipatory bail is not strictly bound by time. It usually extends till the end of the trial. But the lower courts can also limit the validity of the anticipatory bail if there are special circumstances in that case. In MC Abraham versus State of Maharashtra, the court observed that if the application for the anticipatory bail is rejected, if the anticipatory bail is denied by the court, it does not mean that the person has to be necessarily arrested. It will depend upon that case, facts and circumstances. In Badresh Bipin Bhai Seth versus State of Gujarat case, the court said that if the anticipatory bail application is rejected without proper justification by the court, then it will lead to the violation of Article 21, the violation of life and personal liberty. Therefore, while rejecting the anticipatory bail application, the court must give proper justification. In State of Maharashtra versus Vishwas in 1978, the court had also observed that if a bail, anticipatory bail is granted by a court, it can also be recalled, it can also be cancelled by that court. It is only a special privilege, we cannot allow it to be misused. Coming to the article, the court has observed that the provisions of the Criminal Procedure Code shall apply even if the arrest has been made under the Customs Act. The court observed that the facts of the arrest must be communicated to the person nominated or authorized by the arrested person, and it shall be the duty of the magistrate when an arrested person is produced to satisfy that the requirements have been complied with. So the court extended the ratio of Arvind Kejriwal versus the Directorate of Enforcement case, saying that the section 19 of EMLA would equally apply to the arrest under the Customs and GST Acts too. Now, the next article is related to the Waqf Amendment Bill, as the Cabinet has cleared the bill and it will be tabled probably in the Parliament in the second half of the budget session. This is important in GS2 under the topic Governance. What is a Waqf first? Waqf is the endowment of movable or immovable property. That is, giving it for religious, pious purposes or charitable purposes under the Muslim law. Any property can be endowed as Waqf. And as per the Waqf Act 1995, the Waqf property is regulated by the Waqf boards. The Waqf boards are set up by every state. Now, what does the Waqf bill propose? It proposes a few changes regarding the formation of Waqf. For example, a Waqf can only be declared by Muslims who have been practicing for at least 5 years, practicing Islam for at least 5 years. Earlier, that condition was not there. It proposes that the recognition of a property as Waqf based upon long-term use, that is Waqf by user, will not be allowed anymore. The person who is endowing the property as Waqf must be the owner of that property. It cannot be just because he has been using that property for a long time. The endowment can happen when the line of succession ends, the Waqf al-Olad, but the inheritance rights of the heirs of the donor must be protected, especially the inheritance rights of the female heirs of the person who is endowing that property as Waqf property. The government owned property, if it has been declared as Waqf, will not be considered as Waqf property anymore. And the power to determine whether a property is Waqf or not, earlier in the act it was to be done by the Waqf board, but now that provision has been omitted. The survey of Waqf used to be conducted by the survey commissioners, usually appointed by the Waqf boards. Now the survey will be conducted by the collector. A central Waqf council is to be constituted. The council will advise the central and state governments and the Waqf boards. The union minister in charge of Waqf will be the ex officio chairperson. The composition of the central Waqf council has been changed now. The bill requires that at least 2 members of the central Waqf council must be non-Muslims. The MPs, former judges and eminent persons who are nominated to the Waqf council, they need not be Muslims. Out of the Muslim members, 2 members at least must be women. Likewise, the composition of the Waqf boards has been changed. Earlier there used to be an election of the members from the Muslim MPs, MLAs and the state bar council members. Now the state governments can nominate and they need not be Muslims. There must be at least 2 non-Muslim members in the state Waqf boards also. And at least 1 Shia, 1 Sunni and 1 backward class representation must be there in the state Waqf boards. Earlier the requirement was that if there is at least 15% Shia Waqf properties, then there should be representation of Shia. Now there is representation requirement for Bohra and Aga Khani community also. If there are Waqf properties of Bohra and Aga Khani in that state, then at least 1 member from the community should be there in the state Waqf board. Likewise, the composition of tribunals has been changed. The tribunals, they are addressing the dispute over Waqf properties. Earlier there could be a representation of a person knowledgeable in Muslim law. Now it has been replaced with the requirement of a current or former district judge as the chairman of the tribunal, current or former officer of the rank of joint secretary to the state government. Likewise, earlier there was no appeal which could be done on the tribunal orders. The tribunal orders were treated as final and binding. No appeal in any court. Now the appeals against tribunal orders can be filed in the High Court within 90 days of the tribunal order. The powers of the central government have also been enlarged through the latest amendment. That is, the central government can make rules regarding the registration of Waqf properties, the publication of the accounts of Waqf and the publication of proceedings of Waqf boards, and it can get it audited by the CAG or a designated officer. Also, separate Waqf boards provision for Bohra and Aga Khani has been included in the amendment bill. Now, what are the changes that have been accepted by the cabinet and cleared in the latest amendment? There can be 2 Muslim women, members of both state Waqf boards under section 14 and the central Waqf council under section 9. 1 member can be from Muslim OBC community in the state Waqf boards. State governments can have separate Waqf boards for the Aga Khani and Bohra communities. In the family Waqfs, the Waqf alal Olad, women's inheritance rights have to be protected, and the Waqif can only dedicate property if the female heirs get their rightful share. Now, the next article is related to the Hague Convention. This is important in GS2 under the topic Bilateral, Regional and Global Groupings and Agreements Involving India and Affecting India's Interests. The Securities and Exchange Commission in USA has requested the Ministry of Law and Justice in India to serve summons upon Gautam Adani. He is wanted in a securities and wire fraud case in USA. For serving these summons, the SEC in USA has invoked the Article 5A of the Hague Convention, under which the summons can be served. It is also exploring the alternative service under the US Federal Rules of Civil Procedure. Now, what is this Hague Service Convention? This was adopted in 1965 and India joined the convention in 2006. This convention can be resorted to if a country wants to serve summons upon an individual who is in another country. So it helps in cross-border litigation and service of the documents. There are 84 signatory states to this convention, including both India and US. The primary service method is that of requesting the designated authorities. The designated central authorities serve the summons upon the individual, but there are alternative channels also which can be explored. For example, serving summons through email, Facebook, diplomatic channels, consular channels, etc. The USA has although paused the enforcement of the Foreign Corrupt Practices Act. The Trump administration has paused it enforcement for the 180 days, but the filing of the Securities Exchange Commission indicates that this pause does not apply retrospectively. So what has been India's take? India usually rejects the alternate service methods which are provided for under Article 10. For example, the diplomatic or consular channels cannot be used to serve summons upon an individual. The service must go through the Ministry of Law and Justice only. Now, what is the procedure for the serving of summons in India? The documents for service, they must be in English, or if they are not in English, they must accompany an English translation of the summons. The ministry may reject the request for the service of summons also, if there are concerns related to the security of state or the sovereignty of the country. But the rejection of the requests are not merely because exclusive jurisdiction for that subject matter is under the domestic law. And this entire process of the serving of summons takes about 6 to 8 months. Now, what are the judicial precedents in this regard? The courts around the world, they have given conflicting judgments in various cases regarding the serving of summons through alternative channels, that is through email, social media, etc. In FTC versus PCK 24/7, a US court had allowed the service using email or even Facebook service also. But in the Punjab National Bank case in 2019, the English court had rejected the alternate service of summons. The parties sometimes even waive the provisions of Hague Convention, that they will not be bound by the Hague Convention provisions in the contract itself. For example, Rockefeller Tech versus Sinotype. Now, there is a default judgment also which can be passed in case the summons themselves are not serviced, or in case they are serviced but the party does not appear. The default judgment is allowed if the foreign government refuses to cooperate in the case. That is provided for under Article 15 of the Hague Convention. This acts like a safety wall in case there is non-cooperation by a foreign government, but there are certain conditions. After that only default judgment can be passed. The conditions include that the document must be transmitted through convention methods which are mentioned in the Hague Convention, and 6 months must have passed since the transmission of the summons, and no service certificate should be there despite reasonable efforts. India permits the default judgments also even without service certificates. There is a recent case also, Duong versus DDG BIM Services. In this case, the US court has considered giving a default judgment against India as well. The next article is related to olive Ridley turtles. This is important in GS3 under the topic Environment Conservation. The article highlights a report by Dakshin Foundation. It was a 16-year-long assessment report that says that the number of olive Ridley turtles, they have steadily increased. There is a growing population of the olive Ridley turtles, but rising sand temperatures due to climate change, they have caused a large population of these turtles to turn out to be females. Now, if a large population is females only, this raises questions on the long-term viability of the population. These sea turtles, they are usually long-lived, late maturing and highly migratory species, and any change in their population is usually occurring over years or decades. Therefore, long-term monitoring is essential for understanding the population trends and the environmental impacts. Regarding the olive Ridley turtles, they are the smallest and the most abundant of all sea turtle species. They have a unique mass nesting practice known as Aribada. In the Aribada, thousands of females come together on the same beach for laying of the eggs. When we look at the distribution of the olive Ridley turtles across the world, they are found usually in the warm waters of Pacific Ocean, Atlantic Ocean as well as the Indian Ocean. In India, the Odisha's Garimatha Marine Sanctuary is one of their nesting hubs. When we look at their features, they are about 62 to 70 centimeters in length. 35 to 45 kgs in weight. They have 1 or 2 visible claws as well on each paddle like flippers. We can observe that here. They are omnivorous, that is they can eat both plants and animals, and they migrate thousands of kilometers between the feeding grounds and the mating grounds. The conservation status under IUCN Red List is classified as vulnerable. They are listed under Schedule 1 of the Wildlife Protection Act 1972, and they are under the Appendix 1 of the CITES. Now, the next article is related to the Lokpal order on a High Court judge. This is important in GS2 under the topic Statutory, Regulatory and Various Quasi-Judicial Bodies. There was an allegation that a High Court judge had involved in a corrupt activity. He had tied to a private company involved in the case. Therefore, there was the allegation regarding the conflict of interest and corruption. The High Court judge was though unnamed. The Lokpal passed an order that it has the authority to hear cases against the High Court judges. The order did not focus upon the case merits, rather it focused upon the authority of the Lokpal regarding the hearing of cases against the High Court judge. Now the Supreme Court has stayed the order of the Lokpal. What is the rationale that the Supreme Court gave regarding the stay? The court observed that it will affect the judicial independence. It may lead to a possible executive overreach where the executive is prosecuting a judicial member, a High Court judge, and the Lokpal is an executive body. There is legal protection which is provided for the judges. For example, under the Section 77 of Indian Penal Code, and the same is reproduced under Section 15 of the Bharatiya Nyaya Sanhita, the charges cannot be filed against the High Court judges if it is related to the activities done in relation to the official duties. It was further expanded through the K. Veeraswamy case. That was the case related to the Chief Justice of Madras High Court, where the CBI was investigating the disproportionate assets accumulated by the then judge, and the investigation was done under the Prevention of Corruption Act. The court observed in that case that presidential sanction is needed for criminal cases against judges, and it should be done after the consulting of Chief Justice of India. Therefore, judicial protection is provided to avoid frivolous prosecution of the higher judiciary judges and harassment. What is the procedure for the charging of judges now? There is no parliamentary approval required. The parliamentary approval is required only for the impeachment. Coming to the Lokpal Act and the definition of public servant, the public servant is defined under Section 14. The definition does not explicitly include judges, but it includes officers of a body who are established by an act of parliament. Using this logic, the High Court judges may also fall under the category of public servants, since the appointment takes place under the High Courts Act 1861 or the Government of India Act 1935. Even if these acts were there even before our independence, but they can also be treated as acts of parliament using the General Clauses Act 1987. Using this logic, the Lokpal treated the High Court judge as a public servant. Now, the Lokpal has said that it can't hear cases against the Supreme Court judges as per the previous case in January 2025, but it has forwarded the complaint to the Chief Justice of India for guidance before proceeding further, and it has acknowledged the need for careful handling of the cases involving judicial figures. Thank you.